Members, good afternoon. Just gone 2:30. We have the quorum and now call the meeting to order. The subcommittee has completed our discussions on various topics to do with Web3 and virtual assets. The topic for today is protection for investors and users of virtual assets. After today's meeting, should there be further subjects for discussion, you'll be separately notified later on. And our subcommittee is here until the 16th of June, and we'll be reporting to the House on the details. Thank you. Item number 1, I'd like to welcome Mr. Joseph Chen, Undersecretary for Financial Services and the Treasury, and also representatives from the SFC and the Investor and Financial Education Council. First off, I'd like to invite the administration to brief us on the paper and throw the floor open for questions. Chairman, thank you. Thank you very much for the opportunity to brief members on the protection for investors and users of virtual assets, and also our work in relation to education. The virtual assets have brought about opportunities and challenges to safeguard the interests of the investors. We are building up a robust framework, and in this context, in 2022, we have issued the policy statement on development of VA, whereby we have the principle of same activity, same risks, and same regulation. And this is to enhance the VA regulatory framework and also to foster the sustained and robust development of VA in Hong Kong. We'll be promulgating the second policy statement this year to examine how we can tie in with the traditional financial sector and long-term innovation, and also to enhance the flexibility and safety, and also to foster innovation and application of virtual assets. We have introduced the AMLOs, CAP 615, and all the VATPs and N1 marketing VAs. We need to apply for license with the SFC. This is to enhance transparency and also to provide a sound protection system. As of now, this year, 10 VATPs were licensed. The SFC is dealing with other applications for VATP to make sure that all operation will be in line with the requirements. In terms of stable coins, this is playing an important role in Web3. The government introduced the stable coins bill to the council to enhance the regulation, to put in place the regulatory regime. And this will be subject to second reading debate on the 21st of May. And this will provide a regulatory regime, and this will address all the potential risks arising from VA. Should this go through, we will be implementing the regulatory system this year, and all the preparatory work is underway, like regulatory guidelines and the publicity work. We're also working really hard to put in place the regulatory requirements of over-the-counter trading services of VA. We aim to mount a public consultation this year to collect views from the stakeholders to make sure that it will be meeting the public demand. Education is also one of our focuses. Together with IFEC, we are mounting education for the members of the public or the investing public. We have organized a whole host of seminars and workshops. We have media posts or social media posts to remind the investing public to have a look at the list of licensed operators, and also to remind them of the modus operandi of the scams. As of April, we have recorded 880,000 views, This shows that there is a demand for that. In relation to students, we have introduced the animation to hammer the message to the students and to create a sound financial attitude. We have recorded 2.1 million views during the promotion period. We will pay particular attention to the market development and keep VA regulatory framework under constant review and engage the industry in the process to protect the public and managing relevant risks while promoting sustainable development. Thank you very much for attending today's meeting. I welcome questions from the floor. Thanks very much. Mr. Chen, we're here till 4:25. We have on the list Mr. Eric Yim, Mr. Ronald Chen, Dr. Tan Yueheng, Mr. Edmund Wong, Ms. Carmen Khan, Mr. Holden Chow, Mr. Robert Lee, and Mr. Duncan Chiu. We have plenty of time. I allot 5 minutes for each member for the Q&A. Mr. Eric Yim, please. Chairman, thank you. I've got a question and a comment. According to the paper, the VATP will need to hold the client's money through a trust, through a wholly owned subsidiary. And there is a need for insurance policy to cover the potential loss of client VAs. At the present moment, under the trust ordinance, given the rapid development of crypto industry, there is a lack of specific framework for crypto. And many enterprises still rely on the traditional trust. And this is vulnerable to the scammers. And the investor would find it difficult to assess the effectiveness of the protection. Under the protection mechanism, there is this particular loophole with hackers and also the vulnerabilities in the contracts and also the overseas platforms, the flaws associated with overseas platforms. And this might affect the compensation of insurance. In order to build Hong Kong as a crypto center, these must be addressed to safeguard the interests of the investing public. So will the administration be amending the trust companies ordinance to make sure that the trusts will bear the relevant responsibility in the crypto area, like the regular auditing requirements and so on? I've got a recommendation here. I think the government should set up an interdepartmental working group comprising the SFC and the HKMA to monitor the lawfulness or the legitimacy of the deals, and also to carry out examination on a regular basis to enhance the regulation there. Thank you. Thanks very much. I go along with the argument that the custody of virtual assets means that protection would be very important. So we do have the intention that we will be conducting consultation on the licensing of the custodians. I'm grateful to the member for making the recommendation. We heard these recommendations before, and this will be incorporated into our consideration. And we will be liaising with the trade to listen to a whole wide variety of views and then decide on the details regarding the licensing requirements for the VATP operators. And there will be a proper consultation there. Any follow-up? No? Mr. Ronald Chen, please. Chairman, thank you. Like the Undersecretary said, other than the VATP and the stablecoin bill coming up, will be the over-the-counter VA trading. There will be a consultation. The licensing system is on the cards. Now, I've heard this, and this will be conducive to the development of VA ecosystem. Now, we're dealing with regulation and licensing. Now, my question for the Undersecretary is this. Now, with regard to startups for VA, what sort of support will be given? Now, you have all the legislation in the pipeline. How are you going to be promoting the development of this ecosystem? Second, about the education. Now, in fact, the Undersecretary mentioned this. There would be consultation. There would be details regarding the licensing. Now, my question for the Secretary is this. What is the focus of the consultation in relation to over-the-counter VA trading? Third, about the digital asset custody. The government has issued the guidelines back in February last year. Now, whether they will be able to provide a service, they will need to liaise with the Hong Kong MA to make sure that everything is in order. Now, how many operators have been discussed by the Hong Kong MA? Do you have a timetable and a number in particular to share with us? How many authorized institutions will be involved? My final question. 11B mentions the KYC. The clients will need to have sufficient knowledge about VA before providing any services to them to make sure that they have the knowledge. Now, the bank staff would read a long passage to the client, or they're supposed to watch a video clip, or you fill in a questionnaire to make sure they understand everything. In this KYC here, what sort of way are you anticipating will be undertaken to make sure that the clients will be equipped with sufficient knowledge? Will there be there will be transaction limit? Will you require the institution to look at the financial situation before deciding on the transaction limit? Do you have any preliminary ideas for our consideration? Undersecretary, there are 4 questions. Let me address the first 2 questions regarding the development of Web3. And then for the 4th question regarding the operation of the platform, I defer to the SFC. For the 3rd question regarding the authorized institution that we discussed with the Hong Kong MA, I'll defer to my colleague also. The Web3 development, the member has got a point there. We do have a whole set of ideas. We need to create this ecosystem. So this year, we will be promulgating the 2nd policy statement on VA development. It's somewhat different from the last time. Previously, we talked about the principle for regulation and the steps that will be taken, the specific measures for implementation. Now, in this 2nd policy statement, we'll be discussing how there will be an integration between traditional finance and the VA, and how we can have innovation regarding the details. So in this policy statement, we will be enhancing the liquidity, the application scenarios to make sure that there will be better integration between traditional and new finance. And the Cyberport has already set up a Web3 community whereby there would be plenty of opportunity for exchanges. And we also have different publicity. Last week, I attended a summit at Dubai, and we've taken some fintech companies along in the delegation. There are many Web3 companies in Hong Kong, like there is a tokenized fund which has launched some products in Hong Kong, and they are intending to cooperate with the Middle East in this regard. And there are some Middle East funds that would invest in Hong Kong. In the interest of time, perhaps I defer to the SFC regarding the operation of the platforms and the facilities, and I supplement further. Thank you.
係咁
With regard to our KYC work, identifying whether if the customer has relevant knowledge, we don't have any requirements for the trading platforms, but we must ensure that the customers have relevant knowledge. There are different methods. Well, in the end, we may have to conduct a test to see if they really have knowledge. And this is one of the methods in KYC. Another method is to put a cap on how much they can invest. When we approve trading platforms, we will see how they will deal with that. And we will ask the customers whether if they're uneducated or whether they are financially stressed or they are at a high age and are not suitable for high-risk investment. We will take these factors into consideration when we outline the requirements for trading platforms. Different customers will have different investment camps, and these are subject to the personal circumstances. We don't have a fixed rule on how much they can invest at maximum, but we will look at them seriously and see if they have factored in their investment knowledge. With regards to authorized institutions, we have been in touch with these institutions on the requirements for virtual assets transactions. Even they are authorized institutions, if they are to start virtual assets trading, they will have to abide by the current requirements for virtual assets. These authorized institutions, especially banks, if they are involved in virtual asset transactions, they need to work with these licensed VA platforms in order to start operation in virtual assets. I know a few local major banks are involved in this business. Next one is Mr. Tan Yueheng. Thank you, Chairman. Over the past 2 years, the virtual assets market in Hong Kong enjoyed a sound development. On the one hand, the regulators prudently granted licenses. On the other hand, we had effective regulation. We introduced many virtual assets products, which built a very good market environment with risks being properly controlled. We are on a stable development stage. Hong Kong has been one of the important markets of virtual assets, and this is of great importance to strengthening our status as an international financial center. I believe we need to draw from our past experience and step up if necessary so we can enhance Hong Kong's status, increase Hong Kong's market share in global virtual assets market. Regarding the paper we discussed today, I have 3 questions. Number 1, in paragraph of the document, it says by April 2025, we have 10 trading platforms that have received licenses. Can you please explain regarding this 10 trading platforms? How about their operation, their capital size, their source of customers, their turnover, and loss and profit? Can you please shed some light on these factors? My second question concerns paragraph 7 of the paper. In the last part of paragraph 7, it says that we have 8 applications being processed. But here, we're talking about custody, licensing this custody services providers. Are we talking about? I believe custody services providers are totally different from other trading platforms. This is to add another new feature to the current trading platforms. So what's the arrangement for licensing custody service providers? This is my second question. My third question has to do with paragraph 11. Paragraph 11 outlines specific regulatory requirements. We have 8 regulatory requirements. Well, after reading through these requirements, these are do's and don'ts, but in some paragraphs, the wording reads like generally should not or generally should. So it feels to me that we're talking about general situations, but what if we have exceptions? What is general and what is an exception? We're talking about regulatory requirements, which should be very rigorous, strict, and clear. If we are talking about generally, how can we put into practice this 8 regulatory requirements? Undersecretary, 3 questions. Thank you, Chair. Thank you, Member, for the question. Regarding the first question, the current operation of trading platforms, and the third question regarding the wording of these regulatory requirements, I will leave them to my colleagues from the SFC. Regarding your question about paragraph 7 of the paper, custody services. As we said, at present, we plan to start custody services licensing. We will start consultation regarding custody services provided this year. We haven't formulated relevant regulations. We will start consultation this year, but I believe it's good for people to know our thoughts and plans. At the same time, we will collect feedback from the market before we make any adjustments. We will strengthen our exchange with the sector, but with the other questions, I will leave it to the SSV. Regarding the 10 trading platforms that have obtained licenses, when we granted licenses, we conducted an on-site inspection. During the on-site inspection, we discovered something that needed improvement. So they were still improving their internal policies, internal control to be compliant with our requirements. So without completing the internal examination, without completing that, they haven't started their operation. And for those that have started businesses, there are only 2 or 3 of them. For the rest of the trading platforms, if they have completed their internal control examination, they can start business. Regarding the third question about the wording, generally should not. For example, if we are talking about reservation of assets, we say customers' assets should not be used for staking, and we issue the circular allowing them to involved in a certain staking business. So that means for most of the time, they're not allowed to do that. But after our assessment, if risks can be controlled, if we can be more flexible, then we will tell the sectors that they can be involved in the staking business, and we will inform them what extra requirements must be abided by and what new risks that should be controlled. Any follow-up questions? Well, I'd like to know more about that. I believe this leaves some leeway for future services expansion. Is that the intention? Yes, indeed. Next one, Edmund Wong. Thank you, Chair. Protection of investors in virtual assets is essential. We believe if we approach from a regulatory point of view, we need accountants to conduct examination and audit work through annual audits, for example. In paragraph 11G of the paper, it mentions accounting and audit, and they will need to contain a statement in the auditor's report on whether applicable regulatory requirements have been contravened. So will the administration establish some committees? For example, accountants, auditors, or other practitioners from the sectors, people from accounting firms, are they going to be involved in the committee in order to formulating some guidelines? My second question concerns stablecoins. We're going to have the bill committee on Wednesday. We know that Hong Kong Chartered Association of Accountants, they have established a task force targeted at stablecoin, saying what possible measures can be taken to strengthen their accounting rules. So going forward, will you keep close contact with the accountants associations so our guidelines can be fit for Hong Kong and they can factor in the feedback from the sector? Thank you, Chairman. Thank you to the member for the question. I will take the first question and I will leave the second to the SFC. Indeed, on 21st May, we will resume the second read debate for the stablecoin bill. We are doing some preparatory work. We believe after the bill has been passed, we can start as quickly as possible exchange of ideas with the sector so we can seize opportunities so the businesses can start their business and make profit. As for the second question, I will leave it to the SFC. The SFC has been in close contact with HKICA. We know that auditors need more guidance. We used to introduce external evaluation requirements, and the SFC will work with the accountants as well as the trading platforms for evaluation. The reason is that we hope accountants can understand better what level of regulation the SFC is looking for. So with this tripartite communication, we hope that the industry understand better what standards we're looking for. So with more evaluation and with better communication, we hope that the accountants can understand what level we're looking for so they can come up with a good report. A follow-up question. Well, on top of communicating with the standard setters, HKICA, I believe business operators will need to know what can be done, because this is important. We're talking about a tripartite cooperation, regulators and auditors and accountants. They should have sufficient knowledge and experience to do a good job. I hope the administration can involve accountants from different businesses. We hope that they can be involved in task forces or committees so we can implement relevant procedures. Thank you. I have no follow-up questions. Next, Ms. Carmen Kam, please. Thank you, Chairman. Chairman, I found that this subcommittee has some members who are also members of the who are also members of Financial Committee. This time, we focus on investors and users of virtual assets and investors' protection, especially. JPEG's case took place in 2023. In April this year, we received some updates from the Security Bureau. Today, we're talking about the protection of investors. So we could draw some experience from past cases. Can you please talk about that and how we can do better in the future? With regard to the paper, this paper is silent on SPIR, and RE refers to relationship. The roadmap is silent in the discussion paper. I'd like to ask the SFC for the financial influences or finfluences. What's the definition? Because here, according to the paper, the SFC pledges to have a regulatory framework targeting these influences. So in the future, when the members of the public have virtual assets, can you please strengthen education of these investors? Third question, as the Undersecretary knows, we hope that we can start consultation as soon as possible with regard to the OTC transactions. We hope that the SFC can also include OTC transactions as well. I hope the licensing authority shifts from the customs to the SFC. I'm not sure this was discussed at another panel committee. So 3 questions. Thank you.
Thank you, Chairman. Thank you very much for the question. JPEGs and OTC, I'll address this. JPEGs. Since the police have taken over the case, the Commercial Crimes Bureau is following up on this. As of April this year, 2,636 reports have been received. 1.6 billion is involved. 8 people have been arrested. They charged with a conspiracy to defraud, and some leaders are still at large. The asset frozen in terms of property, jewelry, crypto, total $220 million. I think this is by way of the stats of our members' information. I defer to the SFC regarding the details because they have followed the matter up with the police, and the IFEC will also brief members on the education initiatives in this regard. And SFC will brief members on the roadmap in connection with Aspire. Now, we have already conducted a consultation. There will be a second round of consultation, and we will be outlining more of our ideas and also the oversight details and licensing details. I defer to the SFC and IFEC regarding the rest of the questions. SFC, please. In terms of IFEC, I defer to my colleague regarding the education initiatives. But in connection with JPEG's case, going forward, the SFC is going to do certain work for OTC trading and custodian licensing. We will have regard to the transitional arrangement. Perhaps we will not be resorting to a long transitional period, maybe shorter, maybe none. And this is some of the directions that we are contemplating. The whole idea is to get across the message to the investing public about the licensing requirements. About the roadmap Aspire, what the SFC is going to be doing is to start with the licensees. If they are using the KOLs for publicity purposes, there would be certain guidelines that they have to observe, and we will be keeping tabs on the KOLs there in this regard. Now, are the KOLs overstepping the line? Are they venturing into a territory where licenses would be required? Now, we will have a look at this to see the extent to which the power that we can invoke to regulate their speeches or whether we can regulate this from a licensing point of view. All right, IFEC. Thank you. Thanks very much. Since 2023, September since the JPEG incident, the IFEC, myself, and the chairman gave a lot of interviews to the media, and we reminded the investing public that they do need to have the SFC licensed platforms, and it is only when they use this platform that the interest will be safeguarded. And in connection with the risks of overseas platforms, we've also published the information. And on the 6th of October 2023, we have rolled out a Facebook program. We have invited Mr. Chris Hui, the Secretary for SFST, explaining to the investing public all the measures and all the points to watch out for regarding the investment in the virtual assets. Now, we have commissioned the Polytechnic University to conduct an investors' behavioral science study, and this is the first in Hong Kong. We have collected all the data, and we try to get to grips with the behavior and the psychology of the investing public in these virtual assets. And they have to exercise the utmost caution when investing in the VAs. After that particular exercise, we've also followed up on certain studies. We find that for retail investors, about half of the people polled understand the regulatory regime of virtual assets. For those who are involved in investing in the VA, the awareness is as high as 96%. Going forward, we're going to be doing more of the same, and there will be more behavioral science study, and we will be mounting more publicity to the investing public about the areas that they should watch out for. Under Secretary, Chairman, I know they've gone over the time, but very quickly, 2 points, if I may. For these scams, they are hiding behind the virtual assets. They're not really dealing with VAs. Now, for the anti-scam work, we will cover this. Indeed, the police have set up a coordination center regarding scams in this area and heighten people's awareness of these kind of crimes. And they are cooperating with the financial sector. There would be a lot of information swap to take forward this area of work. They also have the alert system whereby they identify some potential victims and give them the alerts. As of last year, 28 banks have taken part, and if they've identified any potential victims, they would give them the alert as soon as possible. So we have all these work undertaken, which will be going on, and we try to prevent people from being scammed or bamboozled by all these scams that are purporting to be VAs. Mr. Holden Chow. Chairman, regarding this licensing regime, Para 11, I see that generally the operators should not lend, pledge, or repledge or create any encumbrances over the client VAs. Now, since the platforms have been up and running, is the administration aware, other than the general trading, is the administration aware of turning this into something else? Now, if they are sophisticated that they can use the platform for lending and pledging purposes. That these platforms have been up and running for some time. Is the administration aware of the level of demand for these platforms? If there are going forward more and more demand for these kind of platforms, and people agree that we should use these platforms for pledging purposes, how are you going to react to this? Also in para 11, you mentioned the insurance policy would cover the potential loss of virtual assets. What sort of insurance policies are they specifically? Thank you. The Secretary, I defer to the SFC on those two questions. Chairman, on the first question, regarding the assets of the clients, back in February, the SFC promulgated the Aspire market, VA market roadmap. We have P there, meaning products, and we are considering the products that can be made available to the platforms. One of them being considered is lending. Now, for securities, is securities lending, but for VA, it is a VA lending and borrowing. This is the area that we are contemplating at the moment, and we will be rolling out the custodian licensing regime, and the custodians are sitting on the assets. Maybe they can resort to lending and borrowing for the clients for more returns to be earned. Now, this is also something that we are looking at as well. And the whole idea to make sure that the platforms will have greater competition. Second, regarding insurance policy, now for the online wallet, the safeguard would be 50%, offline also 50%. There would be insurance policy to guard against any cyber problems, and also to guard against any potential irregularities internally. So in the insurance policies, they have all these different elements, and we would look at the insurance policies of each and every platform to see what they cover. The whole idea is to cover the potential loss of the client VAs. Mr. Robert Lee. Chairman, thank you. Obviously, the administration and the regulators have gone a long way in protecting the investors. Now, there are 10 VATPs that have been licensed, and there are more and more ETFs that are linked with the TPs. Now, I've got a couple of questions here. Now, for these ETFs, we noticed that they have come into existence, and we have to consider how we should enhance them. In different exchanges, they offer similar range of products. So in terms of the daily transaction limit and the admin charges, previously we didn't have these products in the exchanges. Now we do have these products, and they're going to be scaled up. And there might be futures products that may be coming on stream. How can you enhance and improve the ecosystem in this area? And what sort of initiatives and measures do you have up your sleeves in this regard? Second, I noticed that the Hong Kong SL government has issued some tokenized securities products. Now, for the direction of tokenizing the financial products, what position to adopt? We appreciate that the benefits would be to reduce costs, to enhance the efficiency, or to make available the fractional ownership, that whether you're investing in property or artworks, there may be similar products that they can achieve similar purposes. So how will the administration approach this? Are we going to be doing this on a larger scale, or are you going to take a step at a time in terms of tokenization? Third, there are many professional investors. Obviously, retail investors would very much like to take part in similar products. Now, for professional investors, there are certain restrictions. Do you have a specific definition for professional investors? I know that this is something for the future. This is something for the long term. Now, some people may not have the financial capability, but they have the expertise. Finally, if this can be addressed, it would be fine, but if it can't be addressed, so be it. Now, Ms. Carmen mentioned the KOLs. Does the regulator take the initiative to do something about it? In many social media, they would say that they would mention certain background, and you would know certain people making remarks, but there are some people who are unlicensed, and they appear on TV, and they're trying to market certain products. Are you going to be taking an initiative to address these problems?
Undersecretary, please. Thank you, Chairman. Thank you, the member. I'd like to offer some general view before I leave it to the FSC. Indeed, in the development of virtual assets, as I said, this year we will introduce another policy declaration. Now the market has evolved to a certain size, needing more products accessible to investors. As the member said, we were one of the first places to introduce virtual assets futures ETF, and last week we became the very first place in Asia Pacific for virtual assets spot ETF. And in the future, we will start OTC and custody services consultation before we grant licenses. As for the SFC, they have policies targeted at different products and services, making the market more diversified. This is in line with the members' thought. We will not stop here. In the future, we have more product and services in the pipeline, but this should be under the principle of protecting the investors' interests with controlled risks. With regard to tokenization, Hong Kong is one of the places that made progress in tokenization. We are one of the first places offering tokenized green bonds, and we have a white paper outlining our experience, encouraging more practitioners to issue similar bonds, and we have a subsidy scheme for tokenized bond issuance. So we are in very good progress. And when I was in the Middle East, I met a company of tokenized bonds, and they started expanding business in the Middle East. So our tokenization businesses is going very well, but of course, risks must be controlled. I will stop here, and I will leave it to the SFC to talk about regulatory requirements for tokenization, and I will let them talk about professional services, professional investor requirements, the SFC. Well, with regard to tokenization, we worked together on Project Ensemble. The SFC will issue some guidance to the industry so they know that to introduce a product, what requirements they need to meet, any license requirement, or if they're targeting at individual investors, will they need authorization from the SFC? So we will include all these policy guidelines in Project Ensemble. We hope that the industry can try out new technologies. There are many benefits. For example, if we can realize atomic settlement, that's something that we highly expect. We hope that we can work together with HKMA to issue more guidelines. In the future, regarding on the availability of products and services, in spot ETF, we are one of the first markets where ETFs can be used for pledging. At this moment, we have 2 ETFs available at Hong Kong EX, and they are available for pledging. So we hope that investors can make higher returns through pledging. Our Aspire roadmap also states how more products and services can be provided. One of the focuses is derivatives. We hope that the trading platforms can make derivatives possible. We know that in the industry, many investors don't buy spot products. They trade with derivatives. From a risk management point of view, we need to identify extra risks of the investors when they involved in these businesses. As for Finfluencer question, whether we took the initiative to crack down on them, from time to time, we received reports on some misinformation. We will contact X and YouTube. We will ask them to make the video unavailable or delete the post. And we take the initiative to get in touch with the influencers. We told them that they have crossed the line, and these influencers, we asked them to take their videos offline. So we did take some measures to get in touch with these influencers. Next, Duncan Cho. Thank you, Chairman. So allow me to refer to this industry as digital assets rather than virtual assets. Digital assets, I believe Hong Kong has built its reputation around the world in digital assets. We have regulation, we have good products. I'm happy that this topic concerns protection of investors, but I think a lot of questions were about development, not protection. We are indeed in the development stage. Without development, protection is pointless. But now we are faced with fierce competition. Many countries are discussing legislation, investor protection, and new products as well. The U.S. is moving very fast recently. We will introduce a stablecoin bill, and this similar bill was discussed at the U.S. Parliament as well. And the document was very clear. The paper referred to relevant assets as on-chain and off-chain assets. But we're not so clear in our document. So we need to do a better job in education. On-chain and off-chain are good ways to express the idea, but we need to have more products. And my question concerns development. Many members mentioned Aspire roadmap. I think P, products, is the most important one. We have many virtual assets platforms that obtained licenses, and it's important for them to have relevant products. On the platforms, assets available, products available, are they comparable and competitive compared with overseas markets? among these products, if they are not comparable to other markets, we need to have most of these products available if they're popular in the world, as long as we can control the risk. If we move at this speed, we will probably pass legislation only next year. We are probably moving too slow. Many products cannot be made available soon. Are we going to have a roadmap? We have new products in the pipeline. Are they subject to the current restrictions, so they cannot be put on market as soon as possible? Now, for tokenized product, the requirement is for 12 months of transaction, and this will restrict local products. We have exchanges, but we cannot issue products locally. Can we please review these issues? At this point, I believe protection is essential, but which is more important, protection or development? I believe development is equally important, if not more important. So can we provide products that are also available to other overseas investors? Do we have a roadmap? Do we have a timetable? If we need to wait for custody services, regulators, banks, and financial institutions, if they are comfortable with the new legislation and if they are prepared for custody services, then that will be another year. So at the same time, how can we make sure that new products will emerge? Under Secretary. Thank you, Chair. Thank you, Member, for the question. Let me first of all talk about these principal issues before I leave it to the SFC colleagues for the regulatory requirement framework and innovative products and more services. I think the member is exactly right. Development is essential. Development and investor protection are both important. When we came up with this trading platform regulation, many members required that we work on regulation, because only with a sound regulatory framework can people know which platforms can meet their expectation. It's easier for the customer to identify which are the capable platforms. So this regulatory framework is not only to protect investors. At the same time, this regulatory framework is also beneficial to long-term development of the market. On top of the regulatory framework, we have many other areas of work. For example, we have Invest Hong Kong and a task force on fintech. We have a team of colleagues promoting Web3 development. We have specific personnel doing the job. And in Cyberport, we have the community of tokenization and Web3. They have training sessions, different activities, and we have an investment village, so we can put in touch relevant companies and investors. With regard to Aspire and future development and services and flexibility of policies, I will leave them to the SFC. On the provision of new product and services, the SFC is looking into different possibilities. As you mentioned, there is this requirement for 12 months of transaction. Whether this rule can be relaxed, for example, when professional investors who don't need such protection, they can try out this program first. And we are supposed to increase the number of cryptocurrencies that are available. We ask for high market share, high liquidity, because we don't want these digital assets to be prone to market price turbulences. So our direction is that we need to look at if there are products and services which are to be made available to professional investors first. We don't have to wait for the new legislation to be introduced before we start that. We will work at the same time. We will look into the custody regulations and see if there is any room for flexibility. Before the custody services are introduced, we hope that more market practitioners can understand what requirements we are having here in Hong Kong, and if they can make money from the investment here. So before the custody framework, this will be completed. So we will be very active in looking at different possibilities.
Mr. Ambrose Lam. Please turn up the mic. Well, there are some catchphrases like if you relax too much, then it would be giving rise to chaos. If you control too much, then you stifle it. Now we have hundreds of thousands of investors, and there are so many different virtual asset products. Of course, there are speculative activities and also money laundering. The government should do a lot more about that. But there are some crypto assets like startup shares, and they may be having discussion online, and they would get the crypto share for collective decision to be taken. Now, this would be conducive to the startups gathering the talents from all over the world to start the business and to bring together the fund. But this is what the government is doing. I think the government should assist these startups in the development of cryptocurrencies. The government seems to be adopting a high-handed approach. There are lawyers who are reflecting to me that the government is regulating using the SFC securities rules. Now, for cryptocurrency, it would be treated as if they were the IPOs or they were the securities companies. For the pioneers in this trade, they are suffering a great deal because the SFC is applying the listed companies' standards to regulate the funds. If the government requires all cryptocurrencies in this way, I mean, if the regulation is done in this way, then it would be stifling the innovation of Web3, and we will be losing our competitive edge. I'm sure Undersecretary Chen would find that what I'm saying sounds familiar to him. This is precisely what I said 3 years ago when I criticized the stock exchange. Now, with the good efforts of the FSTB, the exchange has changed so much in its attitude. Now, will the administration be using the company's registries model to govern the cryptocurrency instead of stifling their developments? Second, regarding the training for lawyers, this is a bit of a cliche. Now, in future, there would be increasingly more and more disputes over cryptocurrencies. If the lawyers understand the Web3 or smart contracts more, blockchain and all the rest of it, and plus their experience in traditional mode of operation, they would be that much more capable of helping the victims in addressing their losses. So for the Web3 investors, there would be better legal protection. So will the administration be offering any assistance or any subsidies for the lawyers to take part in training courses for Web3 for them to safeguard the interests of the investing public? The Secretary, thank you very much for the question, and thank you for expressing concerns over the development of Web3. Development and regulation go hand in hand. Now, for Cyberport, they have the Web3 community. There are 280 companies that have set up their presence in Hong Kong. They are from Hong Kong and the mainland and some other jurisdictions as well. So Web3 community has been developing pretty rapidly. In February, the SmartCon was held in Hong Kong. There was a Web3 conference. And also in April, we had the Web3 Carnival with tens of thousands of attendances. And Hong Kong's status as a Web3 hub is increasing in importance. And we are leading. We hope that we will be leading the world, and we would like to get a message across that we are positioning ourselves this way. Back in 2022, we have issued our first NFT. Now, we are the first government to issue the tokenized green bonds, and we're the first in Asia to have the spot digital ETF. Now, all these are showing our determination there. I appreciate what the member has to say. Web3 is a vast area. There are certain sectors for which the implementation of regulation may fall short of the sector's expectation, and we may need to improve, enhance the products there. And I welcome comments from all quarters, in particular the OTC trading. We don't have yet the licensing regime at the moment, and the business is going on. And we did the consultation, and we do the consultation again. The whole idea is to make sure that we listen to what the trade has to say, and also to let them know our direction, so that what will happen will not fall short of their expectation. I remember mentioned all these issues regarding the VATPs, the 10 platforms, the products, and the situation. I defer to the SFC that they have published the VA market roadmap. Aspire, this is precisely to address the trade's aspirations. They have rolled out this policy, and would take time for this to kick in. Time is of the essence to the trade. I appreciate that, but they will be implementing this as soon as possible. Lawyer training, we also agree with that. Like Mr. Edmund Wong said, the same can be said about accountants. The professional service would mean a great deal to the trade, and we will be liaising with the Law Society to make sure that while we roll out the licensing regime, the service providers will be able to provide the relevant services to the users. Thank you. Right, for the SFC, we started off with a very stringent requirement. We rolled out the Aspire roadmap in February, and we are looking at the areas where we can relax the restriction to foster vibrant development in this field. We are working hard on this to make sure that the platforms can provide more services and roll out more products to the investing public. And we hope that with these products and services, we will be able to compare favorably with the rest of the world. Now, we are working hard on this in collaboration with the government to see how we can implement the framework for OTC trading while fostering positive development there. Mr. Lam, Like the Secretary said, there are many enterprises that come to Hong Kong for the exhibitions. I am concerned. I'm beginning to be more concerned about this. There are opportunities there. I represent the legal sector, and I think we should talk to the lawyers. And the number of law firms involved in this trade, I think we can count them on 10 fingers. How can we make sure that we have enough lawyers to safeguard the interests of the investors? If the government doesn't devote resources, the lawyers would not be interested in dealing with areas that are of high risk at the beginning. So I do think that we need the government support. I heard that for the 10 VATPs, they are sustaining a loss, and they are investing quite a lot, and they have to go to considerable expenses to do the compliance. So I do think the government should render more support there. Thank you. Any supplement? We've gone over the time. Just very briefly, thank you very much for the comments. For the emerging sectors, we do need to have more training for the professional services, and we will be liaising with the Law Society to see how best we can provide more training opportunities to nurture talents. As regards the operators, that they do have the fixed costs to contend with, but in the long run, their operation in Hong Kong and whether they will be able to do business in Hong Kong, this is dear to our heart. As I said, the SFC's Aspire roadmap is intended to ensure that we can enhance the competitiveness and that the operators would be provided with a sound business environment to do business in and to make profits. Thank you very much for your concern. My turn last. Quite a lot of questions there. The 9 members have already put questions. Some of them are also of concern to me. We're pulling in the same direction. Now, we are talking about protection, but we have to address the fundamental question regarding the development concept. Or should we open up the market, or should we have all the regulatory measures in place first? I've got some more specific questions. We have 10 VATP licenses. Dr. Tan asked about how they are doing. Some said they are sustaining a loss. Maybe they're not having a really impressive performance. Now, we're here to protect the investors. For the we keep saying that we have to do the trading on the licensed platforms, but if the restriction, the regulations are too stringent and they are turning to the unlicensed operators, maybe overseas for trading, not necessarily illegit, they are legit operators, are we shoving them to more risky areas? In terms of investor education, and what will be done? We heard that you have all these clips with 2 million views. Now, this is by no means new. It's been around for a decade or so, and the policy statement has been out there for 3 years. Now, for the media, for the investing public, they find these really new. Should the IFEC mount more publicity to make the public aware of this? In other parts of the world, the participation is pretty high, but not so much in Hong Kong. So in terms of publicity and education, what more will you do? Education is important because the investors who don't know any better might be vulnerable to scams. There are twofold protection. Education is to guard against any scams. Second, if they are scammed what's going to happen? You freeze the asset, people are arrested. Now, how can we recover their losses? Nobody ever mentioned that. Now, my question is, which department will follow up on this? It may not be the FSTB, it may not be the representatives here, but what about the losses that they have sustained? If they have to recover the losses, they may have to take a civil action, and they're very, very stressed. It's stressful business. So shouldn't there be more education regarding this area in terms of the protection for the investors? And there's another area.
Thirdly, many members asked about insurance. Licensed organizations are supposed to be very safe. As Ms. Wang said, we need to protect investors from internal irregulations. But I received some reports that phishing websites attacked these licensed organizations, and some attacks did succeed. Namely, they stole all the virtual assets. Well, it's very likely. Is it possible that these personal assets would be stolen? If no protection, then to some small investors, individual investors, should we maybe expand the scope of protection? Because they were covered by insurance, so they invested with assurance, but in the end, they were still attacked. In the end, I believe this question was asked by 2 members, but I'd like to follow up. Regarding the question about influencers, you said those investors are investing in these licensed organizations, but there are those unlicensed ones. Will you only take actions when something happens? Is it active enough? Because in the past, these influencers, KOLs, were the source of scams. So please think seriously if there are better and more active ways to protect investors. Thank you, Chairman, for the question. 4 questions. I think we need the input from the SFC on all these 4 questions, but I'd like to offer some of my personal views on the first and the 4th question regarding victims of the scammers and looking for compensation. After the JPEX case, some assets were frozen and some people were arrested, and we will follow up on that. I think the best option is to prevent once scams happen, how can we reduce the possible loss of the victims? And we have this anti-scam center, and there was a mechanism, and the center will exchange information with the police and regulators to reduce the possible loss of the victims. So if we can identify possible victims, we can stop their bank transfers, so they will not suffer any loss. And over 30 banks are involved in this mechanism. So we hope that we can use this mechanism to reduce the possible loss of victims. With regard to virtual assets-related services, both the police force and the SFC have cross-departmental task forces. On the one hand, these task forces are to exchange information on preventing scams of virtual assets, and they can enhance risk assessment, and they can strengthen coordination and cooperation. This interdepartmental task force was in place for some time already. Last one, regarding these financial influencers. If these influencers promote investment options, and if their practice involves investments that were only possible to licensed institutions, and then they will fall into regulatory framework. We will identify if these influencers were involved in such practice. We will conduct investigation and law enforcement activities. And now I will leave it to the SFC for the other questions regarding the operation of the platform and the protection of investors and investor education, and perhaps some supplementary information on law enforcement and handling online influencers and cybersecurity requirements for the licensed institutions. First of all, with regard to the operation of these trading platforms, most of the trading platforms are still in the stage of internal examination, internal audit, because we identified some areas for improvement in the previous inspection. So we hope that they can only start operation after they sorted out these issues. But we agree that if regulation is too rigorous, then the products and services are probably insufficient, so that investors from Hong Kong will be driven to other markets to use their services and products. So we hope that this framework can be put into use. Otherwise, people will go to other countries instead. That's why we introduced the Aspire framework to optimize the current framework, offering more flexibilities, offering more products and services that are competitive. So Hong Kong investors will stay in Hong Kong for transactions, and we will continue doing that. Regarding these phishing websites, the SFC does not have the authority to require these phishing websites compensate the consumers for their loss. But we will investigate these trading platforms. We will identify the possible loopholes of these platforms. So they leaked customer information. But we would not exclude the possibility that these licensed institutions didn't have many customers. And if that's the case, then a phishing website will easily steal information from their customers. We will conduct investigation accordingly. If we identify any problems, we will require these licensed institutions to do a better job in internal cybersecurity work. As for influencers, we will identify the cases where the influencers crossed the line, doing businesses that were reserved for licensed institutions. We will take the initiative to combat these illegal practices and start law enforcement activities. Of course, it's better if when these licensed institutions use online influencers services, they should abide by the rules. I'd like to offer some more information on top of licensed institutions. According to current AML ordinance, for the influencers and OTC transaction platforms and advertising tools, we have some regulatory tools available. So regulators have this authority. If we receive reports, and we will keep a close eye on online reports and social media. If we identify problems, the victims can all resort to these legal vehicles. Any additional information on public education through mainstream media outlets?
投委會呢，其實係
The Investor and Financial Education Council started in 2017 a one-stop service platform offering information on virtual assets to the members of the public. For example, cryptocurrencies, initial currency offering, etc. Over the years, we've been working with the administration and the SFC on new regulations or possible cases by collaborating with the police force. If we identify any scams and traps, we will inform the public. We had a few successful campaigns. For example, we have a campaign targeted at young people who invested in virtual assets. We used young people's language so they could understand how it would be possible and safe to invest in such assets. We observed that virtual assets investment has been rising. Its market share increased from 3% in 2019 to 8% at present, and the market increase was more significant for young people, increasing from 6% in 2016 to 26% in 2024. So we took different approaches to educating the investors. As we said, we had a research project on the practices of virtual assets investors in collaboration with the Polytechnic University, and the research results were also used by foreign institutions. Looking forward, we hope that we can receive more feedback from our members. On top of public education, we hope that we can expand our work scope to students or even primary school students. We had a quiz activity with a primary school. Some questions were about virtual assets, and we found that surprisingly, these primary school students were very knowledgeable of virtual assets. And we worked with Cyberport and PolyU in a Web3 workshop, and college students are very interested in Web3 and virtual assets. We hope that we can have more campaigns like that in the future. Thank you again for the question. In the second round, we've seen Comment Cam, please. Thank you, Chair. Having listened to the chairman and other members, I'd like to spend some time asking a follow-up question. Now, as we said, now we will start with the malpractice of the licensed institutions who hired influencers, but these are already they already fell into the scope of regulation. But we are more concerned with those unlicensed institutions. When we deliberate on the stablecoin bill and when we are discussing here, both Ambrose Lam and Robert Lee said the regulatory cost could be very high, but those illegal players, these unlicensed institutions, can be off the cuff. I believe this should be worth much concern. Now you have these Aspire roadmap. If time allows, I'd like to hear more about the timetable of the Aspire roadmap. Without a roadmap, we are not aware when these policies will happen. If these licensed institutions are involved in malpractice, I believe we've seen some reports in March. Some licenses were revoked. If they have crossed the line, I believe you have regulations in Chapter 156. If this licensed institutions are involved in illegal prices, we should let the public know that we're not only targeting at these unlicensed institutions, but if the licensed ones are involved in illegal practices, we will put them, we will tackle them as well. So as for the illegal marketing, I'd like to know more about your recommendations. On top of the unlicensed institutions, what if the licensed institutions are involved in illegal practice?
Second, I appreciate the Undersecretary that you have the 24/7 system. I must declare that I'm also from the banking sector, and if we can exchange more information, then it would do a lot to deal with the scams. But the thing is, the scams have already happened. It is cold comfort. We have to deal with the issues ahead of time. Third, I think, Mr. Lam, Chairman, you mentioned that when we regulate the virtual assets, at the financial affairs panel, we talked about how the FSDC can monitor the situation. We'd like to hear from the administration and the SFC. The last time we asked about the FSDC playing the role of a think tank, can make some contribution. I know that in 2023 I asked a question about this, and it was said that in different jurisdictions for these DeFi DAO organization, there are many young people who are taking part in these kind of virtual assets, and more people are going to be taking part in these kind of investment. How are we going to regulate these DAO? Well, I must say that for DAO, Hong Kong is the first jurisdiction where we have a verdict from the High Court. They're talking about the virtual asset being the property. This is Hong Kong High Court. Right, Undersecretary, 3 questions there. I defer to the SFC regarding the Aspire roadmap, and then I'll come back for the other question. And the timetable, please. Yes, about the timetable for the Aspire roadmap, it's not specifically spelled out in the roadmap itself. Now, for the first limb access, we will look at the OTC and the licenses there. We are proactively liaising with the administration on this. Within this year, there would be a consultation exercise to be mounted. So you get to see the timetable this year. As to attracting platforms and the volume of transactions, we're looking at the regulatory requirements. Now, we have other limbs, safeguarding products, infrastructure. They go hand in hand. We will relax certain requirements and will allow more products and services to be launched in the market. We will then be able to attract more global platforms to come to Hong Kong, and more trading volumes will be flowing into Hong Kong. So all these are being proactively pursued. In terms of custody, as we said, this year we will be enhancing this area this year. So this is going to be happening this year. There will be more to be implemented. As to other elements, infrastructure, under the VA market roadmap, we are building a monitoring infrastructure whereby we collect more market data to facilitate our supervision of the entire industry, not so much the trading platform. We hope that there would be more VA activities in Hong Kong with more data. We would then be able to come up with more regulatory measures or investigation in a timely manner. And we would like to find out whether in a control situation, whether there will be further relaxation that can be possible. It is only on this basis that we would carry out our work. As to the last limb, the relationship, now we are doing something about the influencers, the KOLs, and we said that we will start with the regulator. We'll see whether someone is overstepping the line. And like the Undersecretary said a moment ago, we do enjoy the existing power. If we invoke this kind of power to carry out investigation might take time, but by the time the investigation is done, over and done with, we make the announcement. So it is the same as all the other enforcement efforts that we carried out. We would make the announcement regarding the action that we take. As to the liaison, we will be liaising with the other regulators, the law enforcement agencies. There would be more MOU cooperation. We would exchange more information with other parts of the world to facilitate the oversight. It would be better if we have more data in hand. Undersecretary. Chairman, thank you very much for the question. Like the member said, other than licensed operators, if we find that there are certain KOLs or certain businesses that are suspected of irregularities, under the AMLO, we do have the power to enforce the law. Like the SFC said, they have already done this kind of work. We need to disseminate the information there to keep the public abreast of the situation, and we will do more of the same. Now we have the finance, and this is a platform where the banks would exchange the information. It is spearheaded by the police, and it is an information sharing platform. And this is to make sure that the information can be exchanged in a way that we can tackle the irregularities. In fact, we have submitted the relevant proposed amendments, legislative amendments, to foster the information exchange. Now, if there is a money laundering or AML, CFT activities, the banks will be able to share the information to tackle these kind of activities. The bill will be come to the LegCo next month. Chairman, you understand the background of this case very well. As you said, Hong Kong is the first jurisdiction to handle this particular case, and we will be liaising with the DOJ, and we'll learn how we can learn from this to see how we can take forward the work in the future. Any further questions? If not, that's where we bring this to an end. Any other business? No AOP items. Meeting is now adjourned. Thank you all very much.